And welcome to today's webinar. It's a data protection law update. So my name's Janine Regan and I'm joined by my colleague Sasha Wilson. And here are the topics that we're going to be discussing today. So first of all, I'll be giving you an update on the UK Data Protection Bill with particular focus on automated decision making. I'll then give you an update on the ICO's guidance that they've recently produced on contracts and liabilities between data controllers and data processors. And then Sasha will give you a very comprehensive update on the new EPrivacy Regulation and how that is progressing. Now, please do feel free to type in any questions. I think there's a little dialogue box in your screen, and depending on how difficult they are, we may or may not choose to answer them. There will be a recording of this webinar and a copy of the slides available on our website in the next few days. If you are so inclined to listen to it again or share it with a colleague, it will be available for you to download. But before we get started, we just got a few polling questions that we'd like to pose to you. We'd just like to get your views on some of the headline topics that are governing the data protection newsreel at the moment. So this is the first one. Do you think that the new EPrivacy regulation, once finalised, will have a significant impact on your organisation's online behavioural advertising activities? Yes, no, or I'm not sure. Cast your votes. Okay, the votes are just coming in. And Jane, what are they saying? So is that?
Almost 50%, I'm not sure.
50% not sure. I'm not surprised. There's been so many versions of this draft, it's quite hard to keep track. 32% say yes, you're quite concerned, and 23% of you aren't worried at all. Very interesting, and I'm sure that Sasha will give his input on that very shortly. Okay, so thank you for your participation in that question. We've got two more. This is the second one. How quickly do you think the UK Data Protection Bill will pass through the legislative process? How optimistic are you? Do you think it will go through very quickly or about the usual speed for something like this? Or do you think that it's going to be delayed? Okay, so quite a range of votes. Actually, you're all quite optimistic on this call. So 25% say very quickly, 43% say about the usual time, and 31% of you think that it will be delayed. Interesting, and I'll let you know what I think about that shortly as well. And then finally, and this is just more of a general question because we're getting more and more guidance now from Article 29 and various data protection authorities. How useful are you finding GDPR guidance that's been published by the ICO or other data protection authorities or the Article 29 Working Party? Do you find it very useful? Is it all right? Or do you not find it very helpful at all? What do you think? Okay, not quite so optimistic on this question. Only 12% of you think that it's very useful. About 70% of you think it's all right, and 18% of you don't think it's very helpful at all. So interesting results there. Thank you for your participation. Okay, so let's get started on the UK Data Protection Bill. So last month, the UK government introduced its Data Protection Bill into the House of Lords. Now, the bill is intended to replace the current data protection law that we have here in the UK. That's the Data Protection Act 1998, and it will implement the EU General Data Protection Regulation. And it makes very clear, actually, that it is the government's intention is for GDPR to continue as and when the UK exits the European Union. So as we expected, the bill provides for various exemptions and derogations that all other countries in the European Union are currently legislating for on a local level as well. And many of those are identical to those that are contained in the Data Protection Act. Now, one thing to note is that if you've tried to read the Data Protection Bill, you may have been put off because it's an incredibly lengthy document. It's about 218 pages, and actually a lot of this is probably not relevant for most of you on the call today, because a large proportion of that relates to intelligence services and the implementation of the Law Enforcement Directive. So don't be too put off when you open the draft, because a lot of it won't be relevant for you. Now, as we expected, the bill is very closely aligned with the EU General Data Protection Regulation. And probably one of the main reasons for this is that the government really does hope to obtain an adequacy decision from the European Commission so that it can freely receive personal data from companies or organisations within the European Union that would otherwise have, where there would otherwise be restrictions on transferring data outside of the European Economic Area. And the government set out this in their position paper that I think they published at the beginning of September or around that sort of time. So that's one of the main reasons I think why we do see GDPR implemented so strongly in the bill. Now, whilst there's nothing particularly novel or transformative or massively unexpected about the bill, there are just a couple of points of interest that we thought we'd spend a couple of minutes just taking you through, and I've set out the bullet points for those on the slide here. So the first one is around children's data. Now, the GDPR says that domestic law can determine the age at which a child can consent to their data being processed by providers of information society services or online services. And this is one of the, there aren't many areas actually where member states are able to implement what they think, but this is one of those areas. It has to be between the age of 13 and 16, and as we expected, the bill confirms that in the UK this will be 13. Now, as far as I'm aware, not too many countries have published in their own data protection bills just yet what the age will be for a child. I think it may be Spain, I think, may have come out at 14, I think, but over the coming months we would expect that many of the member states will come out with what they consider to be the age of a child for the purposes of GDPR. Next is the conditions for processing special categories of data and criminal convictions data. So what the bill says, which was a little bit unexpected, I guess, was that if data controllers are processing special or sensitive or criminal data in an employment context or on grounds of substantial public interest, they'll need to implement what's being coined as an appropriate policy document, as an additional safeguard which explains how they comply with the data protection principles and how long the personal data is likely to be retained. And there's an obligation on organisations to make sure that this policy document is reviewed and updated, and that it's made available to the Information Commissioner's Office on request. So I think that this is something really just to keep your eye on. Of course, the data protection bill could be amended. We don't know yet what that's going to look like, but it may be that you need to incorporate something like this or something that achieves this into your GDPR compliance programs. Next, ICO funding. So under the bill, the ICO is going to be able to require data controllers to pay charges to its office, and it may also be able to charge fees for providing certain services. And so this answers the question that quite a lot of people were asking about how the ICO was going to fund itself once notifications or registrations are abolished, which is obviously one of the changes from the Data Protection Act compared with the General Data Protection Regulation. And actually the ICO published an item about this on its blog pretty recently, which confirmed that there's going to be a new fee structure in place by the 1st of April next year. So make sure you keep an eye on that. Brexit. Well, after Brexit, the UK government said that it intends that the standards of GDPR will continue to apply. And what we think will happen is that the government will probably use the powers in the EU withdrawal bill to bring GDPR within the UK's domestic law. Now, I think the withdrawal bill is a hot potato at the moment. It is it's a very political issue, of course. But if it's passed with few amendments, it could potentially mean that once the UK has exited the EU, that ministers could modify UK data protection law without the usual degree of parliamentary scrutiny. And of course, this is a big concern, and there's obviously a lot of opposition against this. So it's something that we, of course, need to keep an eye on. And then finally, automated decision making. So I decided to incorporate this aspect of the bill into today's webinar because the bill itself and recent guidance from Article 29 interprets automated decision making in a way that is, one, at odds with what most practitioners were expecting, and two, it could, if not properly addressed, create actually some quite serious issues with certain types of business. But before I go on, I just want to clarify what I mean by automated decision making for the purposes of this webinar. I mean decisions here that are taken solely on the basis of automated means with no human intervention whatsoever. Okay, so automated decisions. So this has typically been seen as a right that data subjects need to exercise, rather than a more outright general prohibition on these types of decisions. So under the Data Protection Act, this is interpreted that you can make automated decisions about an individual, but they have the right to request that that decision is reviewed by a human. However, the Data Protection Bill and guidance that we've seen recently by Article 29 actually see this as an outright prohibition of fully automated decision making. And this suggests really the general rule is that you can't make decisions solely based on automated means unless one of the relevant exemptions apply. And I've set out what those exemptions are in the third bullet point down there. So the first is that if it's necessary for the performance of a contract, then okay, you can make that decision. But the Article 29 guidance is very clear that necessity should be interpreted narrowly, and if there's any other more privacy-friendly means for you to achieve your aim or to fulfill your contractual obligations, then that's what you need to do, rather than relying on this ground. So very, very narrow interpretation of that exemption. Another exemption would be where the processing was authorised by union or member state laws, but of course that requires those laws to actually be in place, and there are of course going to be gaps, particularly in financial services. And then finally, explicit consent, which of course with consent, as we know, can be withdrawn at any time. So in addition to all of this, so if you do find that you can actually rely on one of the exemptions, you also need to put further safeguards in place in order to make your processing lawful. You need to make sure that you provide meaningful information about the automated decision making, the logic involved, and the significance and envisaged consequences for the individuals. And this quote here is taken from Article 29's Working Party's recent opinion. They say this means ensuring that information is easily accessible for a data subject and it is brought to their attention. So no burying it in a privacy notice is how I would interpret that. Individuals also have the right to obtain human intervention still and to challenge the decision, and under the UK Data Protection Bill it explicitly says that individuals will have 21 days to request data controllers to either reconsider a decision or to make a new one that's not based solely on automated processing. So the good news in this is that lobbying is going on, because I think we do need some clarity here on how these gaps are going to be fulfilled. Okay, so we asked in our polling question earlier how quickly you all thought this was going to get through, and you were optimistic, much more optimistic than me actually. I think it's going to take a little bit of time because the House of Lords really aren't very happy at all with the data protection bill. I put a few quotes here from some various lords, of course, opposition party lords. First one, Lord Stevenson of Balmacara, I think is how you pronounce that, who says the big tech companies have for far too long got away with the conceit that they are simply neutral platforms. They are not, he says. They are active media and information companies, and their stock market valuations are based on the data flows they generate and how they can be monetized. With that role surely comes broader societal responsibilities, but the bill does not go into this area at all. Very, very strong words here from Lord Stevenson. And then he goes on to say the DP bill fails to say how it will ensure data flows. Adequacy is the only card to play, but how, as the bill doesn't address this, UK surveillance arrangements may jeopardise adequacy. And then another Lord McNally, he says the elephant in the room, always in discussing a bill such as this, is how we get the right balance between protecting the freedoms and civil liberties that underpin our functioning liberal democracy, while protecting that democracy from the various threats to our safety and well-being. So quite stern words here from the House of Lords, but we'll continue to keep you updated on how the data protection bill progresses. Okay, so finally for me, before I hand over to Sasha, this is just on the ICO's recent guidance on contracts and liabilities between controllers and processors. Now, I have to say, I don't think there's an awful lot to write home about at the moment on this, but I thought I'd just flag just a couple of interesting takeaways from the guidance. So the guidance does make very clear that processors are on the hook, but equally controllers cannot avoid liability unless they can prove that they were not in any way responsible for the event giving rise to the damage. So the guidance, as the GDPR is, I think, is very explicit on that. One thing, though, that the guidance does help clarify, which the GDPR, I think, is somewhat ambiguous about, is that whose obligation it is to procure these contracts. And the guidance makes clear that the obligation is on both parties to formalise their working relationship. So it's just as much in the processor's interest to get the contract in place as it is the controllers. Contracts need to meet GDPR requirements by 25th of May 2018. So no less up here. The ICO is not going to be going easy on us, I don't think, for not having anything in place by that deadline. This next one I thought was very interesting, actually, description of processing activities. So you may be aware that in your processing contracts, like you already have to do under the German law, actually, you have to describe the types of data that you're processing as part of the controlled processor relationship. You have to explain the purposes, the duration, the scope of the processing, and so on. And I've seen this type of description drafted in very general terms before, but the ICO is clear in this guidance that you can't use general or catch-all terms in this description. You need to be specific about the data that you're processing pursuant to the contract. The guidance also says that the ICO is currently working on security, guidance around security matters under GDPR, which I imagine will be published in the coming months. And they do also point out that, as I'm sure many of you on the call already know, that the ICO and the European Commission do have the ability to publish what they think are compliant standard contractual clauses, but nobody has yet has prepared any such clauses. But it may be something that happens once GDPR is in force and everybody is a bit more comfortable with the new regime. And then finally, I just put a link for you on the slide there, which links to this guidance. If you want to have a look at it, please do just email me and I'd be more than happy to send you a copy. And now I'll hand over to Sasha.
Thanks, Janine, and hello to everyone listening. So I think it's fair to say that the legislative journey of the e-privacy regulation has been nothing if not contentious and nothing if not complex. So I've put up there on the slide, as you can see, a table which shows all of the key documents and opinions and reports and so on that have been published as part of that legislative journey. There was a leak of the regulation published in December 2016, and then the official proposal came out in January. There were some elements which it's quite interesting to note came out of the leaked proposal which didn't appear in the official proposal, and then they've appeared in one way or another in the various versions. Then the Article 29 Working Party and the EDPS published opinions in April, and those opinions were quite similar to each other actually. And then there was a whole swathe of very complex and very lengthy different opinions from the various European Parliament committees and so on. The most recent version of it is the version published by the LIBE committee on the 20th of October, and that was the report which set forth various amendments which the LIBE committee had intended to be put forward for the trilogue negotiation process. We found out today, at the date of recording this webinar, that that version had been approved by a majority in the European Parliament. So the version which we're looking at and which I'm going to talk about, fortunately, is the version which will be put forward to trilogue. But it's very important to note that that is the start of the next phase of the European legislative process. So things can still change. So if you're keeping these slides, please bear in mind they're only up to date as at the date of this webinar. In terms of how contentious the e-privacy regulation has been, it's been relatively fascinating if you follow this type of thing to see the lobbying from both sides. In the top left, there's a screenshot from an online video that you may have seen doing the rounds. It's effectively created by a group of trade bodies representing the interests of internet companies and advertisers, like the WFA, the World Federation of Advertisers, and the IAB, the Internet Advertising Bureau, and so on. And it's been designed to lobby quite strongly against some of the provisions in the e-privacy regulation which are perceived, rightly or wrongly, as being unnecessarily restrictive of the types of business models which various online companies use, and we'll talk in a bit more detail about that. And then on the right is an example of more of the privacy activist part of the lobbying. And you can see there are a couple of tweets from the EDPS which talked about the vigorous nature of the debate ahead of the crucial vote, and that's the vote which occurred today, which approved the LIBE committee report. But in terms of what we do know for sure and things that we can say generally apply in respect of the regulation, the first important point to note, and it may seem quite simple, but it is important, is that it's a regulation. Much like the GDPR, at the moment we have the e-privacy directive, and there's been a relative amount of fragmentation across the member states regarding how that's been implemented. So the e-privacy regulation is very much it has the intention of harmonizing certain areas across Europe. The bullet points there in the slide on your screen, that shows the areas that it covers. The ones I put in red are the areas I'm going to talk about in more detail because they're most likely to be of most relevance to the people listening on this webinar. Point B there, information related to or processed by terminal equipment. That's basically the cookie provisions. We have this term terminal equipment, which effectively refers to end user devices, and there's excuse me, very much an attempt to broaden it out as much as possible so that it captures things like device fingerprinting, which it's worth noting the Article 29 Working Party would say is already covered by Article 5.3 of the EPrivacy Directive. But just to summarize in relation to that, the main concept is this will capture any local device access or utilization of the capabilities of an end user device. There's also some new provisions which capture electronic communications software, in particular browsers, but any other type of software that has a similar functionality. And we'll come on to some of the implications of that. And then finally, electronic direct marketing. It's relatively fair to say that those provisions regarding direct marketing haven't changed significantly, apart from in the area of B2B that we'll come on to. Another important point to note is that the definitions from the GDPR will directly apply in the EPrivacy Regulation. You'll hear lots of people talk about the EPrivacy Regulation as a lex specialis. The best way of thinking about that is it's a layer which sits on top of the of the GDPR, excuse me, and provides some specific circumstances where, for example, a consent requirement is mandated under the EPrivacy Regulation specifically. In terms of consent, Article 9 in the latest version says clearly that the definition of consent, but also the conditions for consent apply. So for those of you familiar with the GDPR, you'll know that under Article 7, there are various conditions which apply to consent. For example, it has to be separated from your terms and conditions, it has to be verifiable, and so on. All of those conditions will apply to the EPrivacy Directive, and that can be very challenging in an online situation, in particular, say, ad tech, where things happen very quickly and the consumer journey and so on needs to happen in real time. Providing for that level of consent is very challenging, and that's partly behind some of the concerns expressed by the online industry. And then the final point worth noting is that the fines, the regime for fines is the same under the EPrivacy Regulation as it is under the GDPR. So there's the two-tier structure of fines with certain provisions triggering the maximum 10 million euro and 2% turnover fine, and other provisions triggering the 20 million euro 4% turnover fine. So looking at cookies, I've extracted there the wording from a version of the LIBE committee report. There have been a few different versions published, but this one shows it as a red line, or a black line rather, and that's quite easy to see. It's not massively dissimilar to the current provisions under Article 5.3 of the EPrivacy Directive, but it's been amended slightly to be a bit broader so that it will capture any type of use of an end user device. You'll see there's the reference to the processing and storage capabilities and so on. What is quite different though is the exception. So as you may know, there are currently some exceptions to the consent requirement for cookies under the EPrivacy Directive. For example, where the cookie is strictly necessary to provide a service requested by the user. An example of that might be shopping basket functionality in an e-commerce setting. There's a much longer list of carve-outs from that consent requirement. That's seen as helpful to online businesses because generally, I think it's fair to say online businesses find consent for cookies quite challenging, but there are lots of conditions. We still have this concept of strictly necessary for the purposes of transmission, and then there's the concept of consent, and then there are other types of strictly necessary, and there are various slightly confusing variations of the level of necessity. I think it's pretty unclear what the difference between something being technically necessary something being strictly necessary and something being strictly technically necessary. That might be something which will get discussed at the trilogue process. There was some discussion of a legitimate interest ground, a legitimate interest exception being introduced, broadly equivalent to Article 6 of the GDPR, and that got people in the online industry very excited because that would allow much more flexibility. However, that doesn't seem to be going ahead now, and that's most certainly, it hasn't appeared in the most recent versions. Other interesting carve-outs are item 6 there on the slide, a reference to the execution of an employee's task. You could imagine where an employee is provided with a device and the employer needs to access that device in order for the employee to operate their task. For example, if they work at a construction site or something like that, and you might imagine they have a specific device which the employer accesses, something like that. But there are various conditions and quite rigorous conditions. In particular, the employer couldn't use it to monitor employees or something like that. Another important and much campaigned for carve-out is the reference to security and authenticity and authentication of devices by way of updates and so on. But again, there are various conditions to that to provide for appropriate safeguards. And then the final one worth mentioning is item 4, and that relates to analytics. There were various differences in how the wording of that carve-out had appeared in these successive versions. Originally, there was a reference to web audience measurement, but that was seen as being potentially a bit outdated, or rather wouldn't be future-proofed. So they've changed it, and now it refers to measuring the reach of an online service. Importantly, that also allows for third-party service providers to be doing that analytics. So where you might use Google Analytics or something like that, for example. But again, there are lots and lots of conditions for that, and I won't go through them in detail. Probably the most highest profile introduction of the ePrivacy regulation has been what I've put up on the slide here in Article 8. It's been referred to as, say, tracking walls or cookie walls or something like this. And this is essentially an online or a digital service seeking consent for tracking cookies so it can target advertising, and not allowing a user to proceed into the site or use the service unless they give that consent. Now, many people would argue that that type of model is already quite challenging under Article 7 of the GDPR. But what this wording from the EPrivacy Regulation does is try to put it beyond doubt that that type of consent isn't acceptable and won't be valid. And this has got a lot of businesses and a lot of trade associations in the internet industry, in the online advertising industry, very concerned because of the perceived likelihood that this could affect their business models, in particular free ad-funded digital services. Again, there's an ongoing debate about whether that's true, and it's important to note that what this doesn't do is prohibit the alternative of a paid-for model being available. And a lot of the high-profile privacy advocates in Europe have been very vocal about that and say this doesn't stop a paywall being provided. This is just a tracking wall to stop people having to hand over their personal data as the only way of getting access to an online service. So this is a very high-profile one, a very topical one, and definitely one to keep an eye on as it makes its way through the legislative process. Some other quite complex and interesting aspects of it are the provisions around privacy settings. So there's still a broadly equivalent concept that exists under the current ePrivacy Directive about the use of technical settings to signal consent. There was a lot of guidance from the regulators that, for example, browsers currently aren't sophisticated enough to allow someone to signal that consent. So the ePrivacy Regulation goes a step further and goes into quite a lot of detail about the use of browsers and appropriate software to provide for that type of consent, and even provides, even mandates and introduces a specific obligation on browsers to provide those types of settings and a effectively disable cookies by default and give users the option to access them. Another slightly complex and unclear aspect of that is the reference to signals from the browser or equivalent software being binding on third parties. So it's probably most likely to mean that if someone selects those settings in their browser to prohibit cookies, publishers have to comply with that. But then there is the option for individual publishers, individual websites, to seek an overriding specific consent for their cookies. Now that's caused a lot of debate and disagreement, because one of the goals of the EPrivacy regulation, and the Commission and the Article 29 Working Party were very vocal about this, that this was seen as a means to simplify consent mechanisms. And in the impact assessment, there was a view that cookie banners and things like that had been very negative for the user experience and really hadn't achieved their goal. So I think it's quite questionable as to whether these provisions in the ePrivacy regulation do that, because a lot of people argue that this is actually going to provide for more consent boxes and pop-ups and so on. The other thing to note is that the obligation on browsers to implement this feature, it has to be introduced by the first update of the browser, or within 6 months of the date to which the ePrivacy regulation applies. And then looking at the direct marketing provisions, and we're talking about e-marketing specifically here, so postal marketing wouldn't be captured, but this is marketing by SMS and email and so on. There's been a debate for many, many years as to whether targeted display advertising would be caught by the definition of direct marketing. What Article 4 of the Privacy Regulation does is put that beyond doubt, I think. If you see the reference or in the definition of direct marketing that I put on the screen there, there's a reference to served and presented. So presented was in one of the earlier drafts of the ePrivacy regulation, and some of the commentary from the Working Party and the EDPS and so on was that direct marketing can take lots of different forms, and it may not just be a traditional email, but it could constitute a targeted behavioral advertising ad, for example. I think the introduction of served there makes it very, very clear that the intention here is that the direct marketing provisions will capture online targeted display advertising, and I think the implications of that are potentially quite complex and will need a lot of thought as these provisions get implemented throughout the industry. The other really quite significant aspect of the direct marketing provisions is the expansion to B2B. And just to clarify, under the current position under the ePrivacy Directive, there's a distinction between users and subscribers, which often gets a lot of our clients quite confused, but essentially the subscriber is the person who pays the bill and so on. And there's a carve-out which allows effectively businesses to send direct marketing to someone at their work email address without getting consent, and that's basically because we aren't the subscribers for our work email addresses. There is an exception if you're, for example, a sole trader, but that's a slightly edge case. But in practice, what the privacy regulation does is quite clearly expand it to individuals, whether they're using that email address in their personal or business purposes. And this, as you might imagine, has caused a great deal of concern in the direct marketing industry, and there are various trade associations, in particular the DMA, the Direct Marketing Association, which is lobbying this very hard because they see this as unnecessary, very detrimental to the marketing endeavors of SMEs who have to compete with the marketing budgets of much larger brands. Again, it's one to watch. It would be, I think it would be naive to make a prediction either way because of the twists and turns that this regulation has taken. Marketers will, however, be very happy to learn that the soft opt-in exception is staying, and as I believe it's been in every version that's been published, so it seems highly likely that the soft opt-in for email marketing will remain, and a lot of the introductory text in the opinions from the the privacy advocates and the various bodies in Brussels, they very much acknowledge that the value of allowing email marketing without consent in an ongoing customer relationship. But one interesting thing from the latest version is the reference to similar products and services being removed from the LIBE committee version. So for those of you familiar with the soft opt-in exception, you'll know that one of the conditions is that the marketer can only email their own similar products and services on the condition of that. That's coming out, and it only refers to their own products and services. So that's quite favourable because it will give a bit more flexibility to businesses. The last point to note is the provisions around voice-to-voice calls. They're broadly equivalent to what they are now, i.e. They can be conducted on an opt-out basis. But what the ePrivacy regulation does do is make do not call registers mandatory, whereas at the moment they're only optional for member states to introduce. So that's everything I had to say on the on the ePrivacy regulation.
I've just got a question for you, actually, Sasha. To what extent do you think lobbying at this stage from various industry groups is going to have an effective impact on the ePrivacy regulations? Is it worth it?
It's a really good question, and it depends who you ask. Obviously, if you ask the lobbyists, they will say yes, very much so. If you ask the privacy advocates, or you could describe them as being the lobbyists on the other side, they would probably be a bit more negative about the ability for all the commercial interests to influence what is ultimately seen as a very positive piece of legislation from a privacy perspective. There have been a lot of twists and turns in the various versions of the ePrivacy regulation as it's moved through the legislative process. I think it's probably fair to say that the version we have from the LIBE committee is probably a bit closer to what the final position will be around things like cookie consents and so on, but it's very difficult to predict at this stage. And for those who followed the GDPR and all the changes that came in right at the end of the process, it would be a bit foolish, I think, to try and make any hard and fast predictions.
Well, absolutely. By the end of the process with GDPR, there were some parts which were completely unrecognisable to the initial draft. We've got actually a question that's just come through. Sasha, I'll leave you to read that.
Sure. So we've had a question that comes in. The question says, so moving away from cookies and LSOs, which are local shared objects, they're a type of cookie, are these prohibitions against digital fingerprinting? The point being, it's less of a browser setting or configuration and more of a more of a move that is a behaviour you shouldn't be doing. So the short answer is absolutely. These are definitely intended to capture fingerprinting or device fingerprinting, and some of the recitals to the ePrivacy regulation expressly say that the consent requirements and the restrictions under the ePrivacy regulation are specifically intended to cover a range of tracking activities, device fingerprinting being one of many.
And in terms of timings for the finalisation of the ePrivacy regulation, Sasha, bearing in mind that we're just about to go into the trilogue stage, how long do you expect this is going to take before all of this business is finalised?
So that's a really good question, and at the outset of the process there was very much an aspiration for the ePrivacy regulation to come into force in May next year at the same time as the GDPR. And as the process went on and the difference of opinion and lobbying in Brussels became clear, that timeline got extended, and it became very clear that May next year was highly unlikely to be achievable. And there's contradictory reports as to when it might come into force. Some reports are saying the end of 2018. Some are saying spring 2019, some say summer 2019, and I've also seen reports that towards the end of 2019 is more likely. So it's difficult to say at this stage.
Interesting. And I think we have just, I think we just have a little bit of time left, just a few tiny updates that I just wanted to share with you, just because we've got a few minutes. The EU-US Privacy Shield has survived its first annual review, which is good news. So there's not going to be a Privacy Shield 2.0 just yet anyway. But there was suggestions that there is absolutely room for improvement in the implementation, and the Commissioner for Justice, Consumers and Gender Equality said, that there is room for improvement, and the Privacy Shield is not a document lying in a drawer. It's a living arrangement that both the EU and US must actively monitor to ensure that we guard over our high data protection standards. So a big sigh of relief for everybody who was waiting for that final review, but of course we'll keep you updated as and when there are any further updates around Privacy Shield, and of course the status of the standard contractual clauses as well. Okay, so I think that's everything. Thank you very much for everyone for your attendance today. We hope that it's been useful. As I mentioned, there's going to be a recording available on our website and a copy of the slides, but if you absolutely can't wait for the slides, then please do let us know.
And also, as a reminder, on the 22nd of November, we're going to be holding another webinar specifically focusing on legitimate interests. So we'll send out details of that as well.
Great. All right. Thank you, everybody.